All right, I am ready. Mr. Flanagan.
Yes, Your Honor.
While I'm finishing up, setting up the live stream, can you please bring in Mr. Matthews for me?
Yes.
Thank you. Mr. Matthews, please start your camera. Thank you. All right, I am ready on Matthews. Give me one moment. All right. This is case number 224526101, the people of the state of Michigan versus DeLon Tajay Matthews. The defendant is charged with 1 count of operating while intoxicated, and today is the date set for a pretrial conference. Appearances, please.
Good morning, Your Honor. Christina Renner on behalf of the people, P number 83505.
And good morning, Your Honor. May it please the court, Lowell Friedman, P56185. Your Honor, I appear this morning by Zoom with approval and consent, along with my client, Daylon Matthews.
And Mr. Matthew, I apologize, counsel, did you say your P number? I'm sorry.
I did. I'll repeat, 56185.
Oh, but you did. Okay. I just didn't remember hearing it. All right. And then Mr. Matthews, please state your name for the court. Unmute for me, Mr. Matthews. Oh, you're not muted.
It was faint.
All right. State your name again for the court.
Hello, you hear me?
I do, sir. State your name for the court. Yeah, he's freezing up. Stop.
Say your name, Daylon.
Daylon Matthews.
And what's your middle name, sir?
Tajay.
Thank you. Matthews, I need you to be stationary. I need you to be stationary, meaning no moving. Today is the date set for a pretrial conference. How are we proceeding, Mr. Friedman?
Yeah, and I'd like an opportunity to speak with Ms. Ritter to see if we can resolve this by way of a plea. I'm in receipt of the discovery, the tender discovery, as well as the video. I'm hoping that we can resolve this by way of a plea bargain.
And so today, that means you're going to continue your client's not guilty plea?
Yes, Your Honor, unless there's any way that I could meet with Ms. Ritter to see if we can resolve this matter today.
No, that's what we do before we come to court. We call the prosecutor and y'all work it out before we come to court. Ms. Ritter is in person in the courtroom. She's not available to go to a breakout room.
Okay, Your Honor, I understand. I'll reach out to her today.
All right, then the court will continue a not guilty plea on behalf of Mr. Matthews, and I will set the matter for a final pretrial conference. And I believe I am available for that on October the 2nd, I think. Mr. Flanagan, am I available on October 2nd? How many do I have?
If I may, Your Honor, I'm in court at 9:30. I will be available by Zoom if it's 8:25 again. That would be great for me.
It's going to be 9 o'clock, but it is on Zoom.
Okay, Your Honor, I'll handle it from the parking lot.
All right, Mr. Flanagan, am I available October 2nd?
Yes, Your Honor. 28 on that day.
So this makes 29. That means I only have space for one more potentially. All right. The court is going to set the matter for Monday, October the 2nd for a final pretrial conference at 9:00 a.m. on Zoom. Bond will continue with no drinking, no driving without a valid license. Anything further?
No, thank you.
Nothing from defense, Your Honor.
All right, then we're all set, Mr. Matthews, until October 2nd. Have a great day. Stay safe.
Thanks, Judge. Have a great day.
All right, you're welcome. Thanks.
Bye-bye.
Bye-bye. All right, I'm ready on Sanchez Guzman. And this is case number. Whoa, okay. This is case number 2145377701, the people of the state of Michigan versus Raul Sanchez Guzman. The defendant is charged with 1 count of assault or assault and battery. Today is the date set for a final pretrial conference. Appearances, please.
Morning, Your Honor. Alan Cooper for the
Hold on,
defendant.
counsel, the people first.
Oh, I'm sorry.
For the record, Your Honor, Christina Ritter on behalf of the people.
All right, now counsel.
I'm sorry, Judge. Alan Cooper for the defendant,
And your P number?
49819.
And Mr. Sanchez Guzman, please unmute yourself and tell the court your name.
Raul Sanchez Guzman.
Thank you, sir. Today is the date set for a final pretrial conference. Mr. Cooper, how are we proceeding?
We would ask for a jury trial to be scheduled.
Court is going to continue a not guilty plea on behalf of Mr. Sanchez Guzman, and I will place this matter on the jury trial track. Mr. Sanchez Guzman, there are approximately 40 cases in front of you for a jury trial. I am waiting for a jury trial date. I'm going to set this matter for a final pretrial conference. Oh, did I leave my other calendar? Give me 1 second. Monday, March 4th, 2024 at 9:19.
9:19 in the morning.
Yes,
Judge, may I request a Spanish language interpreter be available for Mr. Sanchez Guzman?
oh, well, did he need one today?
I think since we're simply just scheduling a new date, I think that it's fine. He can understand some things, but I think that it might be best for future proceedings if we have a Spanish language interpreter.
Oh, all right. I wish I'd known that today. Mr. Sanchez Guzman, did you understand that I'm adjourning the case?
Yes, today,
Okay.
yes.
Okay, thank you. Yes, okay. Then the court sets the matter for March. What did I say? I'm sorry. March
It said March 4th, actually.
Yes, March 4th at 9:19, and that just lets me know that there's a jury trial needing to be scheduled. And yes, we will order a Spanish interpreter, you said?
Yes, Judge.
All right. We
And
will
then
have a Spanish interpreter.
Thinking that court date on March 4th is a final pretrial date. Is that
Final
correct?
pretrial, and I will give you your jury trial date at that time.
Okay.
Hopefully, I'll be able to give it to you. It'll be like the fall. They are supposed to be making some adjustments to my docket, so that may change and I may be able to give you something earlier, but right now, that's what it is.
Great.
All right?
Thank you,
Then we're all
Judge.
set. You're welcome. Have a great day. Stay safe.
You too.
Thank you, Your Honor.
Thank you. You're welcome.
You have a nice day. Thank you very much.
Thank you. All right, Ms. Ritter, you can go ahead and go and talk to your witness.
Okay, good.
All right, Ms. Arnold, good morning. I am going to send you to a breakout room to speak with the lawyer. Please remain in the breakout room until a lawyer has come in to speak with you. Do not leave the breakout room until you have spoken with the lawyer, okay?
Yes.
I hope you're not getting dressed, Mr. Polk. I hope you're not. I just hope you're not. I hope you're not getting dressed. I hope you're already dressed for court. Oh, wait, what did I just do? Miss Arnold, why I don't see you on the, oh, there it is. Oh. Oh, thank you. Okay. Let me bring her. That's a mess, and I'm just gonna delete him. All right, let me bring her out. Miss Arnold, I apologize. You already have a lawyer, so I'm going to put you in the waiting room, and we'll call your lawyer. Okay. All right. Well, first, let me change your name. All right. Mr. Polk, don't ever come to court again. And well, first of all, you on the bus, and I'm not going to have court with Mr. Polk on the bus. And then no. And then he got to put his ear up to the phone because he can't hear us because he's on the bus. And I'm trying to figure out why was he outside getting on the bus with his shirt off, logging into court with his shirt off. It was very rude and it was very disrespectful.
If you can let me,
I'm not going to have court with Mr. Polk on the bus. So, Ms. Stevenson, I don't know where he's on his way to, but I'll put him in a breakout room. But let's be clear, I won't have court with Mr. Polk on the bus. I will not have court with Mr. Polk on the bus. He's not listening. He's doing a whole bunch of stuff. He's not even looking at his screen. I mean, it's just so distracting. I can't imagine. So if you would please look at your screen and accept to join a breakout room. Don't have no attitude with me. Don't have attitude with me, because if you have attitude with me, it's just not going to work out for you, but it's going to work out for me. Ms. Stevenson, you might need to go in and talk to Mr. Polk, because I don't know where he's on his way to on the bus, and he's supposed to be in court.
Yes, Your Honor. Shall I go now, Your Honor?
Well, he's still on the screen, so I don't know.
I'm
Mr. Polk, join your breakout room, please, sir.
I removed him. He didn't go to the breakout. I removed him. Are we ready on Williams Ross? No, I mean, ma'am, what are you doing?
Are you
This
asking
is
me?
ridiculous. No. This is, now, let me say something to you. I don't know who met with Miss Williams Ross in the breakout room, and I don't know what instructions were given in the breakout room. But ma'am, if you sleepy, don't log on the court. If you're gonna go to sleep while you waiting, don't log on the court. If we have to bring you out of the room and see your thigh, don't log on the court. I'm just telling you, this is unacceptable. You need to be sitting upright. Sitting upright in an upright. It's not a conversation. This is not a conversation we're having. This is not a conversation we're having. And I'm gonna send her back to the breakout room because it's not gonna work out well for Miss Williams Ross this morning. I'm gonna send her back to the breakout room because she's confused and she's lacking understanding on the proper way to come to court on Zoom. So we're gonna send her back to the breakout. Stop doing that. Put your hands down. Put your hands down, ma'am. She's gonna go to breakout room number 5, and Miss Stevenson, you're gonna go in breakout room number 5 with Miss Williams Ross.
Yes, Your Honor.
Miss Blackwell, I'm gonna put you back in the waiting room and I'll bring you back out shortly. Miss Ryman, were you the intern that spoke with Miss Williams Ross?
Yes, ma'am, I was.
I'm gonna send you to the number 5 with them.
Okay.
Ms. Stevenson didn't come back out. All right, Mr. Murad, are you ready on, are you already on something? Oh, never mind, just hold tight. Ms. Jefferson is here. I'm gonna handle her case and then I'll be ready again for MFD. Good morning, Ms. Jefferson. Good morning.
Good morning.
Good morning. Are you ready on, Ms. Arnold?
Yeah, I need to speak to the prosecutor.
It's not possible, Ms. Jefferson. You got it. Or court, she's in the courtroom. She's not on Zoom. We have a trial starting in a minute.
Some reasonable efforts towards the permanency goal to adopt the recommendation.
Okay.
And I think it may be appropriate.
Let me look at, I believe I got it in my notes. I think I know there's an offer.
Schedule something.
My client and I have had many discussions
so that
and
we can get the report back from.
Okay. Well, all right. Okay, I'm ready on Williams Ross. Okay, this is case number 234465501. The people of the state of Michigan versus Fatima. Middle name starts with an N, last name Williams Ross. Defendant is charged with 1 count of assault or assault and battery. And today is the date set for a pretrial conference. Appearances, please.
For the record, Your Honor, Christina Renner on behalf of the people and the complainant witness is present on Zoom this morning. Ms. Blackwell, unmute yourself and just state your name for the court.
Kennedy Blackwell.
Okay, next.
Good morning, Your Honor. My name is Elisa Rahman, and I'm a second-year student in good standing at Detroit Mercy Law and request permission.
We're gonna stop. Ms. Stevenson, what's wrong with her presentation to the court?
She's sorry.
Somebody set her up for failure today.
Ms. Rockman is trying to make, she has a lot of moving parts, Your Honor. Ms. Rockman is actually a student in good standing at a law school accredited in the state of Michigan. And we would move that the court grant her permission to practice pursuant to Michigan Court Rule 8.120B, I think it is, under the supervision of myself and Mr. Murad.
That's a shame. That's a shame that I would stop her in the middle of her sentence because she was trying to say some other law school besides Wayne State. That's a shame that I would do that. Shame on me, but I'm gonna do it next time too. All right, permission granted.
Thank you, Your Honor. Eliza Rahman, appearing on behalf of Ms. Williams Ross. Ms. Williams Ross, can you please state your full name for the record and also consent to me appearing on your behalf?
Fatima Nadia Williams Ross, and yes.
All right, today is the date set for pretrial conference. Ms. Rahman, how are you proceeding today?
Your Honor, we are asking for a final pretrial conference with the request for discovery, please.
Court is going to continue a not guilty plea on behalf of Ms. Williams Ross, and I will set this matter for a final pretrial conference. Mr. Flanagan, how many do I have on November 6th, please? Oh, no,
Yeah.
I don't mean it. What's today's date? I'm sorry. 11. How many? Oh, I'm not here on the 13th. How many do I have on November 14th, please?
6.
Thank you. Court is going to set the matter for a final pretrial conference, November the 14th. At 9:00 a.m. Discovery should be submitted to the defense by October the 13th. Bond will continue with no contact with the complaining witness. Ms. Blackwell, you have appeared today, and therefore, ma'am, you are not required to appear on November 14th. However, as the complaining witness, you may appear at all scheduled court appearances, but you are not required to appear on November 14th. If you do not appear on November 14th, you should contact the prosecutor's office to find out when the next court appearance is and whether your appearance is required. Anything further with respect to Ms. Williams-Ross?
No, thank you, Judge.
No, Your Honor.
All right, then we're all set until November 14th at 9 a.m. on Zoom. Ladies, have a great day and stay safe.
Your Honor, could Ms. Williams-Ross go back to breakout room for her interview, please, with Ms. Rahman?
All right, yes.
Thank you.
All right, Ms. Blackwell, you're all set, ma'am. And I will move Ms. Williams-Ross to breakout room number 1, as well as Ms. Rahman.
Thank you, Your Honor.
You're welcome. Ms. Jefferson, are you ready?
Your Honor, I'm sorry. I do need to speak to the prosecutor. I thought I had to, so I can once again relay to my client what the offer is. I believe I know what it is, but I'm.
Ms. Ritter, what's the offer on this case?
Planning hearing will be on the
And
21st,
Ms. Jefferson, you're gonna have to lower the volume on your other device.
I intend to make two
Very hard for me to
Any
hear.
party disagrees, you have 7 days to seek review after.
I'm sorry.
That's good. What's the offer, Ms. Ritter?
Impaired, Your Honor.
That's the offer. Did you want to
That's what I
speak to the
thought.
client in a breakout room?
Yes, please.
And then Ms. Ritter, are we ready? I'm not Ms. Ritter, I'm sorry. Are we ready? We're ready on Cohill and Nelson, correct?
Correct, Your Honor.
All right, Ms. Arnold, I'm going to send you to a breakout room number 10. It should pop up on your screen and your lawyer will come in to speak with you. All right.
Thank you, Judge. Thank you
You're
so much.
welcome. All right, I'm ready on Cohill and then Nelson. Cohill is having trouble coming in. Oh, there we go. Okay. All right, this is case number 164564201. The people of the state of Michigan versus Alexis Renee Cohill. The defendant is charged with 1 count of malicious destruction of property. Today is the date set for a pretrial conference. Appearances, please.
For the record, Your Honor, Christina Ritter on behalf of the people.
Good morning, Your Honor. My name is Daniel Galley. I'm a 3rd-year student in good standing at the University of Detroit Mercy School of Law.
Oh, pop. Ms. Stevenson, in a minute, I'm getting ready to say no. I'm going to say no. If these students going to keep trying to go rogue and put their school on my record, it's no schools on the record.
Sorry, Your Honor. I'm a 3rd-year student in good standing at an accredited law school.
Oh, yes, it is accredited. It is an accredited law school.
And I request permission to practice pursuant to Michigan Court Rule 8.120B under the supervision of Attorney Dennis Stevenson and Mr. Raid Murad.
Ms. Cohill, you almost didn't have a lawyer just now. I'm just playing with you, Ms. Cohill. Ms. Stevenson would have stepped in. She would have stepped in. All right. Permission granted.
Thank you, Your Honor. And for the record, is Daniel Galley appearing on behalf of Ms. Cohill, who consents to my appearance on her behalf. Is that correct, Ms. Cohill?
Yes.
And state your name, Ms. Cohill.
Alexis Cohill.
What's your middle name, ma'am?
Renee.
Thank you. Now, Mr. Lipper, if you try it, I'm gonna say no. You better practice your speech right now. Okay, Ms. Cohill, I apologize. I am exercising a little bit of levity this morning. Please forgive me, but laughter is sometimes good for the soul. She like, don't laugh on my case, Judge. All right, today is the date set for a pretrial conference, Mr. Now, see, I didn't even pay attention to your how to pronounce your last name because I was so focused on you saying this other law school on my record. How do you pronounce your last name, counsel?
It's Galley.
Galley, okay. Mr. Galley, how are you proceeding?
Today, Your Honor, we move for dismissal for the complaining witness failure to appear today.
Ms. Ritter?
Judge, so this case was arraigned by Your Honor, and the court scheduled this pretrial conference requiring the complaining witness, Ms. Doretha Cohill, to be present. I don't see Ms. Doretha Cohill in the waiting room, Judge, and I don't have an explanation as to why Ms. Doretha Cohill is not present. So at this time, Your Honor, the people will not be able to proceed based upon the complaining witness's failure to appear for today's pretrial.
Today is the day set for pretrial conference, and even though it sounds like this shouldn't be my case, the complaining witness was required to appear. They have failed to appear, and the people have no explanation for that failure, and they are unable to proceed. The court is going to grant defense counsel's motion for dismissal and dismiss the matter without prejudice. Ms. Cohill, the court will mail you a copy of the order of dismissal for your records, okay?
Okay.
Have a great day and stay safe.
Thank you. You as well.
Thank you. All right, I'm ready on Nelson. Looks like we could have started the trial at 10 o'clock. Sometimes, but see, if I had said that, then we would be going until, yes. All right, I'm ready on Nelson, and this is case number 234464901, the people of the state of Michigan versus John Andrew Nelson. The defendant is charged with 1 count of retail fraud. Today is the date set for pretrial conference. Appearances, please.
For the record, Your Honor, Christina Ritter on behalf of the people.
Good morning, Your Honor. My name is Matthew Lippa, and I am a third-year student in good standing at an accredited law school and request permission to practice pursuant to Michigan Court Rule 8.120B under the supervision of the attorneys of misdemeanor felony defenders.
Perfect speech.
Thank you.
Permission granted.
Matthew Lippa appearing on behalf of John Nelson, who consents to my appearance on his behalf today. Is that correct, Mr. Nelson?
Unmute Mr. Nelson, please.
Yes, I consent.
And state your name, please.
John Andrew Nelson.
Thank you. Today is the day set for pretrial conference. Mr. Lippa, how are we proceeding?
We move for dismissal today, Your Honor, as the complaining witness has failed to appear.
Ms. Ritter.
Judge, the corporate complaining witness, Home Depot, does not have a representative in the waiting room, and the people have no explanation as to why our representative on behalf of Home Depot is not present. So at this time, Your Honor, the people will not be able to proceed based on the corporate complaining witness's failure to appear for today's pretrial conference.
And this is the second scheduling, so I'm assuming that means that Home Depot did not appear at the first scheduling?
That is correct, Your Honor.
Today is the day set for pretrial conference. The complaining witness was required to appear. They have failed to appear. The people have no explanation for the failure. They are unable to proceed. The court is going to grant defense counsel's motion and the matter is dismissed without prejudice. Mr. Nelson, we will mail you a copy of the order of dismissal for your record, sir. Have a great day and stay safe.
You too, thank you.
You're welcome. Oh, wait, I brought Miss Arnold back in, but what happened to Miss Jefferson? Oh, Miss Jefferson's still in the breakout room. Okay, why is Miss Jefferson? Okay, Miss Arnold, give us a moment. I thought your lawyer was on screen, but maybe she was on 2 hearings. So I'll bring you right back out when she comes out of that breakout room, okay? Let's try to bring in Mr. Polk again. Maybe he's reached his destination, but maybe not. No, he has not. I mean, just a complete mess. Just a mess. Ms. Stevenson, okay. Can't even. All right. Don't know about Ms. Jefferson, but we'll be on recess until Ms. Jefferson comes back or Ms. Stevenson gets Mr. Polk stationary and ready to attend court. Oh, let me check my email. Mr. Flanagan,
Yes, Your Honor.
can you please call Mr. Torres and let him know that I sent an email this morning? And if someone would please respond to my email regarding Shavonte Jackson.
Yes, ma'am.
Thank you. You ready? You early, counsel, you early. Yes, you ready? You ready?
I put a tie on for you.
All right, but I'm glad to see you because that made me think about getting the chairs ready for the trial.
Can I help move anything?
Oh, no, we don't have any money to pay on the deductible if you hurt your back. Officer, who is my officer? Officer Crafts?
Yes, Your Honor.
I need 3 council chairs and 3 defense chairs for the defendant's side of the table, please.
Yes, Your Honor.
You all can take that chair from the jury box, jury seat number 8. And then we might have to get my chair out of the hallway, but I probably might need my hallway chair. So you might have to contact procurement. But we need 3 and 3. 3 and 3. All right, I was just saying that it looks like I'm gonna finish my morning docket early, and wouldn't it be nice if I could have started my trial earlier?
Well, you know, it's always a pleasure to be here, and when everybody comes, I'll check in with Ms. Ritter.
All right, I'll be downstairs after I finish these last couple of cases. All right. Mr. Flanagan.
Yes, Your Honor.
Oh, wait, hold on. I have muted my device. Wait. All right. Can you also call Ms. Jefferson, find out why she's still in the breakout room?
Yes, ma'am.
I mean, I guess she was on another hearing. I don't know.
Okay.
Okay, look like I might be ready on Mr. Polk. This is case number 2244244501. The people of the state of Michigan versus Amir Rashard Polk. The defendant is charged with 2 counts of assault or assault and battery. And today is the date set for pretrial conference. Appearances, please.
For the record, Your Honor, Christina Ritter on behalf of the people.
Janice Stevenson appearing on behalf of Mr. Amir Polk. Mr. Polk, sir, please tell the judge your full name.
Amir Rashard Polk.
All right. Today is the date set for pretrial conference. How are we proceeding?
On behalf of Mr. Polk, we thank the court for hearing this matter. Mr. Polk will, on his behalf, we move for dismissal for the complainant's failure to appear.
Ms. Ritter.
Your Honor, it's at least the second scheduling of the pretrial conference, and the court requires the complainant witnesses, Mr. Tashawn Brown and Ms. Asia Taylor, to be present for today's hearing. I don't see neither of the complainant witnesses in the waiting room, nor do I have an explanation as to why the complainant witnesses are not present. At this time, Your Honor, the people will not be able to proceed based on the complainant witnesses' failure to appear for at least the second scheduling of the pretrial conference.
Today is the day set for pretrial conference. The complaining witnesses were required to appear. They have failed to appear, and the people have no explanation for the failure. The court is going to grant this. The court is, in a minute, I'm going to say Mr. Polk just got to come in person.
Be still, Mr. Polk. Be
Oh.
still, like a picture.
I mean, he doing so much. It's just been a struggle having court with you this morning, Mr. Polk. You came on showing us your bare chest. We didn't want to see it, but you showed it. You showed it.
And I apologize.
Quiet, Mr. Polk. Just be
Oh.
quiet and listen.
Because you apologizing for showing us your bare chest is of no consequence. There should not have had to be an apology because we're in court. And who would come to court with their bare chest? Who would do that? No one should. And then I had to deal with you being on the bus. And you're acting as if you're doing me some type of favor. But you're not. You're not doing me any favor. This is your court date. The complaining witnesses were required to appear. They have failed to appear. The people have no explanation for the failure to appear. They are unable to proceed. The court is going to grant defense counsel's motion, irrespective of and in spite of the defendant's personal behavior today. The court is going to grant defense counsel's motion and dismiss the matters without prejudice for failure of the witnesses to appear. We will mail a copy of the orders of dismissal for Mr. Polk's records. Have a great day and stay safe.
Thank you, Your Honor.
You're welcome. I'm ready on Arnold. This is case number 214443401. The people of the state of Michigan versus Camry Amanda Arnold. The defendant is charged with 1 count of operating while intoxicated. And today is the date set for a final pretrial conference. Appearances, please.
For the record, Your Honor, Christina Ritter on behalf of the people.
Good morning, Your Honor. For the record, Thomasine Jefferson on behalf of Camry Arnold.
Your P number, please, Ms.
P
Jefferson.
42872, I'm sorry.
Ms. Arnold, your name for the record, please.
Tammy Amanda Arnold.
Thank you. Today is the date set for a final pretrial conference. And the matter is scheduled at 9:10, which should denote a trial on my docket, but I don't see it in my book. Mr. Flanagan, when is this trial scheduled for?
March 11, 2024.
Oh, it's in the future. Okay. All right. March 11, 2024. All right, Ms. Jefferson, how are we proceeding?
Your Honor, at this time, the people have offered, made Ms. Arnold offer that if she pleads to driving while impaired, they'll dismiss the original charges, and she's prepared to enter that responsible plea. Thank you.
You said she's prepared to enter a responsible plea.
Well, guilty plea.
Oh, okay. Ms. Arnold, your lawyer has indicated that you want to enter a plea today. Is that what you want to do?
Yes.
Ms. Ritter, I apologize. It's so dark in that courtroom. I can't see Ms. Ritter. The whole courtroom looked like it's dark to me, but I know y'all gonna tell me all the lights are on. Ms. Ritter, is that the people's offer for the operating while visibly impaired?
Yes, Judge, the people's offer is to reduce operating while intoxicated to operating while visibly impaired.
All right, ma'am, I am going to share my screen. On my screen, you will see an advice of rights form. My question to you is, have you had an opportunity to review for yourself or to go over with your lawyer your constitutional rights?
No, we haven't.
All right, then I am going to review them with you.
Okay.
Court will skip number 1 and go to number 2. Do you understand that you have been brought to court on a misdemeanor charge and you therefore have the following basic rights? You have the right to plead guilty, not guilty, or stand mute. If you stand mute, a plea of not guilty will be entered on your behalf. You may plead no contest with permission of the court. You have a right to a trial by jury, and you have a right to the assistance of an attorney. Do you understand those rights? Do you understand those rights?
Yes.
You have the right to an attorney appointed at public expense. Counsel, are you appointed or retained, please?
Retained, Your Honor. Thank you.
Thank you. I'll jump down to number 5. Do you understand that if you have a trial in this matter, you have the following rights: to call witnesses to speak for you at trial, to get an order signed by the court requiring witnesses to come to court. You have a right to see, hear, and question all witnesses against you at trial. You have a right to be a witness for yourself or to remain silent. Should you choose to remain silent, the prosecutor would not be able to comment on your refusal to testify. You have a right to be presumed innocent unless proven guilty beyond a reasonable doubt. Do you understand those rights?
Yes.
Do you understand that if I accept your plea today, you will not have a trial of any kind and you will be giving up your right to a trial?
Yes.
Has anyone threatened you in any way or promised you anything that was not placed on the record today to get you to enter into a plea?
No.
Are you currently on probation or parole?
No.
This is a misdemeanor. It is punishable by up to 93 days in the Wayne County Jail, up to $500 in fines plus costs. There is no mandatory minimum jail sentence. Additionally, fines, costs, and other financial obligations imposed by the court must be paid at the time of assessment unless the court allows otherwise and for good cause shown. If you are not able to pay due to a financial hardship, you must notify the court immediately. Do you understand?
Yes.
Finally, drawing your attention to number 11 on the advice of rights form, it indicates that an appeal to the circuit court may be taken within 21 days from the date of your sentence or as permitted by law. That if you are unable to pay for an attorney, you could ask the court to appoint counsel on your behalf for the appeal. However, do you understand that by entering into this voluntary plea, you may be giving up your right to an automatic appeal? And if you were to change your mind about the plea, you would have to either request permission of this court to set aside the plea or request permission of the circuit court to appeal the conviction. Do you understand?
Yes.
With that understanding, do you still want to give up your rights and enter into this today?
Yes.
Ma'am, raise your right hand for me. Do you swear or affirm that the testimony you are about to give will be the truth, the whole truth, and nothing but the truth, so help you God?
Yes.
You may put your hand down. Who's going to voir dire Ms. Arnold with respect to the factual basis for the plea?
I can't judge.
Go ahead.
All right.
May I, Your Honor?
You may.
Thank you. Ms. Arnold, on October 19, 2020, were you near northbound I-75 and Mac in the city of Detroit?
Yes.
And is that the county of Wayne?
Yes.
And at that time, at that location, were you operating a motor vehicle?
I was in my car, yes.
And before operating a motor vehicle, did you consume any alcohol?
Yes.
Do you recall what you consumed?
No.
What? Okay. The alcohol beverage that
Say that again.
I'm sorry, go ahead.
No, you go ahead, Miss Ritter. What was your question?
The alcohol beverage that you consumed prior to operating that motor vehicle, did it impair your ability to safely operate that motor vehicle?
Yes.
Judge, and the people stipulate to the blood alcohol content of 0.119, and with that, the people are satisfied.
Your Honor,
Satisfied?
defense was so stipulated and we're satisfied.
The court is not satisfied. In response to in response to the people's question as to whether she was operating a motor vehicle, she said, I was in my car. That's not sufficient. Was she operating the motor vehicle?
I'm sorry, Judge.
I'm sorry?
I said I wasn't driving. I wasn't driving, so.
So how am I supposed to accept a plea from a person who said she wasn't operating a motor vehicle?
Your Honor, if I may ask her a question.
You may.
Okay, Ms. Arnold, at some point prior to the officers arriving, had you been driving the vehicle? If you can recall.
Ma'am, I need you to be still though. I'm sorry.
I'm sorry, I'm trying to get my phone charger, but yeah.
So at some point you had been driving the vehicle prior to the officer's arrival at the scene, correct?
Correct.
I don't understand. I still don't understand.
The police, my car was parked.
You had been drinking.
Mm-hmm.
And when you were drinking, after you were drinking, you operated the motor vehicle.
Yes.
And then at some point, the police came to a place where you was parked in the motor vehicle.
Yes.
But you had been operating the motor vehicle after you had been drinking, correct?
Yes.
Okay. All right. The court is satisfied. I will accept the guilty plea to one count of operating while visibly impaired. Having accepted the guilty plea, the court is going to set the matter for sentencing October 16th, if that's a good day for you, counsel.
Let me double check that date, please. It's actually not a good day. I can do the 15th or the 17th if the court has that available.
But the 15th is a Sunday, but the 17th.
Oh, I'm sorry. I'm looking at the wrong date. The wrong month, rather.
So can you do the October 16th or no?
No, Your Honor, I'm gonna be in trial.
Okay, so then what what's a good day that week? What about that Friday, the 20th?
Oh, okay, I'll be here.
Okay, so then let's set the sentencing for Friday, October the 20th. Ms. Arnold, you have a right to be sentenced in person or on Zoom. Which do you prefer?
Zoom is fine.
Court will set the sentencing for 9 o'clock on Zoom. Prior to sentencing, you must submit to a pre-sentence investigation and a substance abuse evaluation through the probation department. They are going to contact you by telephone. If they cannot reach you, they will mail you a letter and leave you a message directing you to contact them at a particular time. Please make sure that you respond to their phone call or their letter so that we may have a proper pre-sentence investigation on the date of your sentencing. Ms. Jefferson or Ms. Arnold, I need one of you to contact my courtroom to make sure we have the current information for Ms. Arnold, her address and phone number. Who's going to call?
I'll call Your Honor.
And do you have my courtroom phone number or do you need it?
I think I need it, but he has called me, but yes.
All right, 965.
Okay,
2295.
thank you. Thank you so much.
All right, you're welcome. Anything further with respect to Ms. Arnold?
No, Your Honor, that's it then.
All right, then everyone have a great day. Stay safe.
You too. Thank you. Bye-bye.
Whoops. Mr. Flanagan, you may have to call Mr. Wade then.
Okay.
Mr. Allen, turn your camera back on. All right, you're a little dark, so you may have to adjust your sitting situation. However, please accept to join the breakout room. Wait for a lawyer to come in to speak with you. Join breakout room number 5, please. Number 2, I'll send you the 2. Well, it sent him to 5. It's like it won't listen to me. I said 2. And then let me share my screen for your other client. All right, ma'am, I'm going to send you to a breakout room. Please accept to join the breakout room and then wait for a lawyer to come in to speak with you. Oh, wait, how did I send? I didn't mean to send a person to number. That's so silly. Y'all, Zoom doing what it want to do. It won't send the people where I'm trying to send them. Okay, Mr. Allen he gonna be so tired of moving around. He's been in 3 breakout rooms. All right. Okay. All right, now, ma'am, please accept to join breakout room number 5. All right. Oh, Ms. Stevenson, did you make Mr. Murad aware of the reason we brought Mr. Al-Saidi back? He really did. She not there. She off doing something else. She not really there. Let me go in and talk to Mr. Murad. Mr. Flanagan, I'm gonna go ahead and come downstairs, okay?
Yes, ma'am. And Your Honor, I just spoke with Ms. Bumpus. She said she sent you an email on Jackson.
No, she didn't. That's not even her case. It's Miss, okay. Let me look and see.
Yeah, she said on behalf of Ms. O'Driscoll.
Oh, I was getting ready to say, oh, she just did. Oh, okay.
Yep.
Oh, yeah, she like literally, okay, because y'all don't, okay. Let me send this to Ms. Stevenson. All right, I'm on my way downstairs.
Okay,
Okay.
I stepped outside and I'm not sure what I even stepped out there for, but I got caught up in something.
You did, and we was talking to you. You weren't there. We weren't, whatever. But I went into the breakout room on your behalf to let your colleague, Mr. Murad, know why Mr. Al-Saidi was back today.
Okay,
And now I'm on my way downstairs. Mr. Flanagan, I'm gonna make you the host while I come downstairs. Because
Okay.
Ms. Ritter and Ms. Stevenson,
is she gone too? We're both just
they both
gone.
gone. They don't, you know, so let me make Mr. Flanagan the host, and I'll see y'all downstairs in a little bit.
Okay. Okay.
Green is in the building, so I just talked to him, so he's coming up. Morning.
Morning.
Ms. Ritter, can I call your cell real quick?
No.
Calling now.
You can call her. She better not answer that phone in here. She
Oh,
can
hey,
answer.
Judge.
Hey,
Are you guys about to start?
you thought that was somebody else?
I thought that was Miss Ritter saying no.
Oh, that's funny. You can call her.
All right, cool.
You may.
Can I come around?
You may. Mr. Murad still has, Mr. Murad still has the jailer. All right, so these are both reviews. I'm disappointed I didn't bring my review sheets. I didn't bring my, so you have them, did I give you some for both of them?
I didn't see anything for Carnarvon.
Oh, and on, I printed the, for that one, I just. I assumed that I placed her. Have a file for this
Check.
Is there a probation order in here?
Yeah.
Okay, all right, so we're gonna be out of order, Judge. Is it okay?
Yeah.
Okay.
I hope.
Well, actually, maybe we will be at one, or should be.
I think I'm two,
Okay.
but because
He's two.
I'm two.
Okay.
It doesn't matter. I'll figure it out.
Okay, Judge.
Yeah, I just ordered her to do the jam of the diamonds. And pay. Okay. Regarding Alan, he has. I think you talked to somebody else.
I did.
Mr. Dobbs just.
For Mr. Allen?
Yeah.
Great.
Sign. Yeah. All right, well then let's do yours first and then I'll do Alan.
Yeah.
Ms. Mason,
Yes, Your Honor.
I'm gonna do your client and then I'll do that.
Yes, Your Honor.
Ready? Okay. This is case number 22443670 the people of the state of Michigan versus Sherry Lee Carnarvon. Carnarvon. Defendant is charged with one count of gambling, disassociated person. Today is the day set for review. Ms. Stevens, your appearance, please.
For the record, Your Honor, Janice Stevens, I'm appearing on behalf of Ms. Sherry Carnarvon. Ms. Carnarvon, may I please tell the judge your full name?
Unmute.
Unmute. Okay. Sherry Lee Carnarvon.
Carnarvon. I know we always say it wrong. Today is the day set for review. And I placed Ms. Carnarvon on a delayed sentence on April 20th for a period of I don't know.
I think it's 9 months.
All right, 9 months. And then, yeah, its final review is January. This would be the halfway point. How are we proceeding?
Your Honor, at this time, I do have a
screenshot, I don't want to publish it, Your Honor, but it's a screenshot of the gambler's not.
Oh, yeah, because she shouldn't have that.
Exactly, and so that's the only proof that she has of that. She has a call into her counselor with regard to the gambler's counseling, where she's, I think, attended 11 sessions at this point. We just don't have the proof of it yet for the court. She's waiting to get that from the counselor, and the balance is now 0. The plea was taken pursuant to MCLA 771.1. I would ask the court for a very brief adjournment for Ms. Carnavon to give us proof that she's completed the gambler's counseling, Your Honor, at which point I would move to dismiss the matter.
All right, when you say a very brief adjournment, what do you mean?
Ms. Carnavon, how long do you think it's gonna take for your counselor to get you the letter?
Well, hopefully soon. I'm gonna call her again. Because I did miss her call when I was on hold for the Zoom call, and so I couldn't answer it.
So she'll probably have that proof today.
Oh, yeah, today.
To, October the, what's planning? Is her balance 0? Did you check?
I just balance is 0.
All right, so. I think 15, 25. All right. How many do I have on September 25th? Let's do September 25th. Anything further?
Nothing further. Thank you very much, Your Honor.
All right, ma'am, you're all set until October 25th. Have a great day. Stay safe.
Thank you, you too.
You're welcome.
October 25th.
Mr. Flanagan, can you call Mr. Johnson? He's not connecting. Mr. Murat, are you ready on Mr. Al-Said?
No, Judge, I got disconnected. Could I get my privileges back so I can wrap that one up?
I just gave him back to you.
Thank you.
All right, because I'm getting ready to start my trial.
I'll be super quick, Judge. But Your Honor, that might be a plea.
Okay, well,
I'll be quick though.
it's a bench trial, so I can interrupt myself.
Got it.
Okay. I don't know, Mr. Dots isn't connecting, so I'm gonna go ahead and start it.
Contact.
Oh, you don't?
Did you get it home?
Yeah,
Yeah, it says Ms. Stevenson listed up.
I know, that's why I didn't know nobody's coming. All right, then let's get situated. Each defendant can come up to the table, please. And you're gonna sit behind your lawyer. So Ms. Stevenson is sitting the closest to the podium. And then. Yes, okay. So, and then let me just take a visual note. So I actually have, yes.
I could actually push this up just a little bit.
Yes, please. So Ms. Stevenson is actually number 3, so I had 3, 1, 2. That's how they're saying. Mr. Allen.
Yes, ma'am.
So you spoke to the misdemeanor and felony defender's office this morning. However, it appears that your original lawyer has logged in. do you have a phone number from Mr. Dox?
Yes, ma'am.
Can, do me a favor, do you know how to use the chat?
I never used it, but if you let me mute him, if you let me mute myself, I'll be able to call him off a different phone. If you allow me to mute myself.
Yes, mute yourself and call him, because he's here, but he's not connecting, like he's not connected to his video or his audio, and I'm getting ready to start a trial.
Okay,
So,
ma'am.
call him and see, I'm ready.
Okay,
All right.
just give me like 30 seconds, please.
Okay, no, go ahead. All right, I'm ready on Al-Saidi, that's Al-Saidi. All right, this is case number 234467701, the people of the state of Michigan versus Hasham Ahmed Al-Saidi. Defendant is charged with 1 count of assault or assault and battery. Today is an adjourned date for a pretrial conference because I made a mistake on, I think he was here on Friday. Well, it wasn't my mistake, it was the people's mistake. Nonetheless, we made a mistake on Friday. And we dismissed 2 cases instead of 1. It should have only been a dismissal as to 1 case. Appearances, please.
For the record, Your Honor, Christina Ritter on behalf of the people.
Brian Murad, P83665 on behalf of Mr. Hisham Al-Saidi, who's on Zoom from the Wayne County Jail. Mr. Al-Saidi, state your full name for the record, sir.
Hisham Al-Saidi.
All right. Thank you, sir. And please accept my apologies for misleading you last week. I know we said both cases were dismissed, but as I indicated to your lawyer this morning, the complaining witness on this case actually appeared. They had appeared, and so it was not proper for me to dismiss the case. All right, so today being the adjourned date, and I don't know if I said on the record last week, but officially the court sets aside the dismissal that I said on the record last week, and I did not sign an order of dismissal for this case, but I signed an order of dismissal for the other case. Mr. Moran, how do you wish to proceed?
Your Honor, at this time, it's Mr. Al-Saidi's desire to tender a plea of guilty as charged in this particular matter. We're asking the court to recognize that he has been incarcerated on this matter with a parole hold. We are hoping for an immediate sentencing.
All right. Sir, have you had an opportunity to review for yourself or go over with your lawyer your constitutional rights?
Yes, ma'am.
When you went over your constitutional rights, sir, did you understand your constitutional rights?
Yes, I understood it. Yeah.
Do you understand that this is a misdemeanor and therefore you have a right to a trial? But if I accept this from you today, you are going to be giving up your right to a trial.
Yeah, I understand that.
Has anyone threatened you with anything that was not placed on the record to get you to enter into this plea?
No.
All right. And then I know from our previous contact that you are currently on parole, and in fact, you are currently being held based upon that parole hold. Is that correct?
Yes.
And do you understand that by entering into this plea, this most likely will be considered a violation of your parole?
Yes.
With that understanding, do you still want to enter into this plea today?
Yes.
All right, raise your right hand for me. Do you swear or affirm that the testimony you're about to give will be the truth, the whole truth, and nothing but the truth, so help you God?
Yes.
All right, you may put your hand down. Mr. Moran, are you on board here?
Yes, Judge. Mr. Al-Saidi, sir, I'm going to take you back to May 19, 2023. At that time, sir, were you in the city of Detroit and the county of Wayne?
Yes.
On that same date, sir, did you come into contact with a one Mr. William Estes?
Yes.
And did you strike Mr. Estes?
Yes.
Did you have permission by Mr. Estes to strike Mr. Estes?
No.
Your Honor, defense is satisfied.
Satisfied. Court is satisfied. I would accept a guilty plea of 1 count of assault or assault battery. Mr. Murad, I know you want immediate sentencing. Unfortunately, due to the victim's right to make a statement, I cannot impose immediate sentencing. But what I will do, Ms. Ritter, do you have contact information for that? This is the victim that showed up.
I do, yeah.
I will try to do a quick turnaround for a Zoom sentencing on Wednesday and give Ms. Ritter an opportunity to contact the victim and see if they want to make a victim impact statement, but I have to allow for the victim to make a victim's impact statement.
Wednesday, what?
Mr. Moran, he'll explain it to you. I said I can't sentence you right now because the victim has a right to come in and make a statement, but I'll send you back to the breakout room. Mr. Murad, if you could explain that to him, but I'll bring him back Wednesday. I'll let the prosecutor contact the witness and see if they want to make a statement.
Thank you, Your Honor. And that's the 13th of this month, correct?
Yes, 13.
Thank you very much, Judge. I'll explain that to Mr. El-Saidi in breakout room.
Okay, I'll send him back.
Thank you.
All right. All right. I'll put that on for Wednesday. Yeah. Mr. Dox?
Good morning, this is Mr. Doc's assistant, and he's coming right now. He's in the other courtroom. He's coming out.
It's only one person can let the assistant check in for him. That's Daniel. Yeah, P number P2 something.
Good morning. Good morning, Your Honor.
Mr. Dox, P number 2 close to mine for him to be talking about his assistant checking in. Good morning, Mr. Dox.
Good morning.
I'm ready on Allen. We thought your representation had ended. So please accept my apology. I sent your client in to speak with the defender's office. So he did speak with the defender's office this morning, but please accept my apology for that. This is case number 215615901, the People versus Kenyatta Jawan. Allen, defendant, is charged with 1 count of weapons purchasing without a license. Today is the date set for review. Mr. Dox, your appearance, please.
Good morning, Your Honor and Honorable Staff. Attorney Quentin Dox, P number 79657, on behalf of Mr. Allen. Mr. Allen, please state your full name for the record.
Kenyatta Jawan Allen.
All right. Somebody gave me a paper. Y'all know I will lose some paper. I will lose paper. Did I give it back to you by mistake?
Yeah.
Oh, okay, thank you. All right, today's the day set for review, and I have an update from Ms. Bumpus. Stating that I placed Mr. Allen on a 9-month probation, and I did that back in 2022, but on May 16th, I extended his probation to November. He has completed 3 sessions of anger management, and he still owes $400 on this case and $2,100 in total to 36th District Court. Do you want to just continue him to his final review date and see?
Yes, Your Honor, please.
Okay. All right, and then switch it back to Mr. Dox. All right. All right, so let's get it done, Mr. Allen, okay?
Yes, ma'am.
All right, so I'm gonna continue you to November 16th at 10 o'clock p.m. And then let's finish that anger management. You need to, if you can't pay the total that you owe to 36th District Court, you need to sign up for the payment plan, okay?
Okay, and how do I do that, Your Honor?
Talk to your probation officer. They'll help you sign up for the payment plan.
Okay.
All right.
Thank you, Mr. Allen. You're all set. Well, if you have any questions, call me, Mr. Allen.
Okay, thank you.
All right, good to see you, Mr. Dox. Have a great day. Stay safe.
Good seeing you too, Your Honor. Stay safe.
All right, thank you. All right. Okay, who is this? Tell the lawyers I'm ready.
Lawyers, the judge
oh.
is ready.
They supposed to be here, but I'm not gonna be able to do them. Mr. Murad,
Yes, Your Honor.
do you see the person that's in the waiting room? Don't call their name. It's a HIDA case. Do you see them? Do you all have a phone number for that person? Ms. Stevenson?
I don't have it with me, Judge.
Well, let's rename the person. I'm gonna rename them, bring them in, and then you talk to them in the waiting room, but I'm getting ready to start my trial, okay? Did we get a report on that person?
I didn't see that one.
So Judge, we're just getting them a new date?
Yeah, get them let's give them a new date. Let me see if I got a report. I did. Oh, it's good. He doesn't have any remaining conditions and he is, I think it's his discharge date. He's gonna be discharged.
Judge, can we just waive his appearance and I can send them out?
Yeah, well, I'm gonna just discharge him, but, let's let him know what's going on.
Will do.
I'll bring him in the break. I'll bring him in and then you can, just tell him what's going on, okay?
Did you send it to me and I overlooked it?
I don't know.
Oh, okay.
No.
All right.
Oh, I did forward it to you. But, I forwarded it to you Friday at 1:59 p.m. I was working early, I was getting it done early. The person I just let in the breakout room, in the courtroom, please accept to join the breakout room. All right, they're discharged, Mr. Murad. Okay, then I'm ready. Turn the camera away from me. All right, this is case number. And then zoom it out like, I guess. This is case number 184543303, the people of the state of Michigan. Strike that, 3301, the people of the state of Michigan versus Keith Wayne Ditmore. 02, the people of the state of Michigan versus Corey Devon Spencer. And 03, people of the state of Michigan versus Derek William Abramski. The defendants are each charged with 1 count of assault aggravated, and as to each defendant, today is the date set for waiver trial. Appearance, please, on behalf of Mr. Ditmore.
Roger Free on behalf of Mr. Wayne Keith Ditmore.
And your P number.
P62260.
And Mr. Ditmore, your name.
Keith Wayne Ditmore Jr.
Thank you. On behalf of Mr. Spencer.
Your Honor, Jeffrey Sherbo, P25324, on behalf of Mr. Spencer, without an assistant calling it.
He was trying to let me know, Judge, I'm P2 too, so I'm gonna get away with some stuff during this trial. We're gonna see.
Well, just the last guy.
I know, with a P79. Mr. Ditmore, please state your name, sir.
Mr. Spencer.
I'm sorry, Mr. Spencer, yes.
Corey Devon Spencer.
Thank you. And on behalf of Mr. Abramski.
For the record, Your Honor, Janice Stevens, P57708, appearing on behalf of Mr. Derek Abramski. Mr. Abramski, please tell Judge Bryant your full name.
Derek William Abramski.
All right, today is the date set for waiver trial. With respect to the trial, are there any preliminary issues before we begin? Gentlemen, you may be seated.
Judge, I didn't know.
Oh, you did?
Yeah.
Oh, you're right, I did. Isn't that something? And I'm a stickler for the people going first. You mean I let all 3 of these people put their appearance on? Ms. Ritter, don't take it as anything other than, I don't know what to take it as. Ms. Ritter, your appearance, please.
Thank you, Your Honor. Good morning, Christina Ritter on behalf of the people, P number 83505. Your Honor, I also have my officer in charge, President of the courtroom, who's standing up to my right.
Morning, Your Honor, Detective Derek Mason.
Thank you. All right. Again, I apologize, Ms. Ritter. Are there any preliminary matters before we begin?
Just a couple on behalf of the people doing. One, the people did file an amended complaint with the court, adding the lesser included offense of count 2, assault and battery. I did get notice and copy of those amended complaints.
And I do see it now on my desk. Any response from any defendant with respect to the amended complaint?
On behalf of Mr. Spencer, and for the purpose of the reporter, should I indicate my name each time or?
No.
Okay. I just find it absolutely incredible that we've been here for 5 years and we get this today. I understand that it may in fact be a lesser included offense, but we had one charge and that's what we've been coming for. You've had final pretrial conferences, and to amend it on the day of trial, I think would be improper.
Anyone else?
I would agree, Your Honor, on behalf of Mr. Ditmore, Your Honor. Just add, when it said 5 years, it's over 5 years, Judge, since it had happened. And we've had numerous court appearances, appeals on certain issues. And it's just another example of them trying to harass and intimidate the defense judge to add this charge now. We would raise our objections for the record.
And anything on behalf of Mr. Bryant?
And for the record, Your Honor, I do understand that people have, this is not, it's not untimely according to the court rules, Your Honor, but I would concur with Brothers Counsel that we've been at this for a number of years at this point. And I do, I have the highest regard for Ms. Ritter and the way she practices law, Your Honor, but we do believe it's a little bit, the ninth hour to come with an amended charge, even if it is the lesser included offense, Your Honor. We take it as a surprise, but I do understand it's not outside of anything that the court will permit her.
All right, the court is going to allow the amendment as the court rules to indicate that people have a right to amend the charges up to, through, and including trial. The court allows the amendment. Anything further?
Yes, Judge. In addition, Your Honor, I did speak with Sister and Brothers Counsel regarding the photos of the injuries sustained by the complainant witness, and they all have stipulated to the
On behalf of, just say it on in the order that you begin, because this is 3-1-2.
Okay.
3-1-2.
On behalf of Mr. Bramsky, Your Honor, having had the opportunity to confirm with people with regard to the photographs of the alleged injuries, Your Honor, at this point, we are going to stipulate.
On behalf of Mr. Ditmore.
We would stipulate, Your Honor, would ask the court just to let us cross-examine before we admit it in at that
Absolutely.
time.
And then on behalf of Mr.
I would have no, Spencer, Your Honor, I would have no objection to that procedure. I assume it's the photos that have been previously provided.
Absolutely, and she'll show you before she presents it.
And with Mr. Farina's proviso, absolutely no problem.
All right. Anything further?
One last thing, Judge. So during final pretrial conferences, there was a stipulation by people for the medical records that were, I guess, obtained by the complainant witness on the day of the incident. And the people did stipulate to the copy that was provided in the summary. However, Mr. Sherbo just showed me another version of the medical records that the people stipulated to. People are not stipulating to the version of Mr. Sherbo has provided, but that's not the same.
And is that something that's going to come up now or in the defense case?
Well, it's going to come up, Your Honor. First of all, I don't disagree that this isn't a different set. This is the full set that was subpoenaed in the civil case from, the certification to the end. The records that were provided in discovery, assuming they're the records we have, they do have the pages of interest to us, which would be pages 20 and 21 on the documents I gave Ms. Ritter today. If you look to confirm, those are the pages that showed that there was a blood alcohol content of 0.245. And that's really the only page. The rest is superfluous, so I can't say that.
So, this is the way I'll handle it. I don't know how it's gonna come into play. If there's something in the record that the people have not stipulated to, that is, being presented to the court, then I'll address it at that time. So the record that you stipulated to, Mr. Sherbo says, is included in the record that he gave you, which it sounds like you're saying the record that you gave her is a complete record. And the other part that she stipulated to was partial of that complete record.
As I understand it, yes, Your Honor. Again, and I can't find my copy of this record, pages 20, 20, really page 20 is the only page we need, because it says on the bottom ethanol serum 0.242, and that's the emergency documentation. I believe that was in the stuff that we got from the prosecutor's office. Really, I just wanted a complete copy, but page 20 is the only one.
I have the 4 pages that you're talking about included in that they did give to us, Judge, which has the 0.242 alcohol ethanol.
All I'm saying is, and I'm not saying that the other pages are not admissible. What I'm saying is, as it relates to the people's stipulation, I will receive the pages that she stipulated to. If there are any other pages, she can consider stipulating to them. And if not, depending on how they're being presented, you may have to bring in the keeper of the record.
Okay, on behalf of Mr. Branson, before the court just rules on it, can I just have a quick conference with Ms. Rick?
Sure.
I want to make sure that.
Right, that's why.
That's why you came down.
That's why I came downstairs.
Okay, yeah.
I mean, I pushed it because I came home and I thought I missed it. But it's, that it was down, that's why I walked, instead of walking all the way down to the.
Down for a few days last week too.
Okay.
That's the date, so it's.
Great.
All right, anything further?
Not from us, Your Honor.
Nothing on behalf of Mr. Branson.
We'll let Zane do it. I'm not hoping how they don't use the word funds, so I don't know how to.
They said they stipulated it.
Oh, okay.
But you know, I don't need to see, maybe, I might not need to see it in the opening, but if you, well, let's just go with it. There are many witnesses, nobody asked me for sequestration.
I'm standing up for.
Oh, okay,
Look for sequestration witness.
all right, and, Ms. Ritter, are you requesting an exception?
Yes, Your Honor, with the exception of my officer in charge, who is present, Detective Mason, who is in the officer in charge on the original case.
Right, and he the reason why I adjourned my trial that I wasn't happy with, your OIC, but we're here. Okay, we're here and we're ready to proceed,
I'm trying to
okay?
see if I have an objection to the noise.
You can place it on the record, but I'm gonna overrule it.
All right, well, never mind.
All right, the motion for sequestration is granted. And the people's request for the, exceptions for the OIC is also granted. So, if there's anyone in the room that will testify today or in the future on behalf of the people or on behalf of the defense, with the exception of the officer in charge, you must leave the courtroom. Additionally, everyone is prohibited from, so I am live streaming the trial. And everyone is prohibited from watching this trial on YouTube. I am going to question every witness that takes this witness stand under oath as to whether they have viewed any portion of these proceedings on YouTube, okay? Anything further?
Yes, Judge, one other.
Oh, yes.
We have a witness, Ms. Paris Floyd, that's out in the hallway, was subpoenaed by the prosecution. But she can't testify Wednesday when we kind of our case, but can we have her testify tomorrow afternoon? She's out of town, that's in her job. She's here and she testified.
Mr. Farina, can I ask you one favor?
Yes,
I might ask you another one, but right now,
yes.
the plexiglass is still real and I can barely hear you.
So what I was saying, Your Honor, is that Miss Floyd, who's a witness called by prosecution and used by us as well, is in the hallway. She was subpoenaed for this morning, but we'll need her for Wednesday. Sorry, she can't testify Wednesday. We probably need her for tomorrow afternoon, so we'll have her come back tomorrow afternoon.
Do you think, is that someone you're using?
Judge, the people who just subpoenaed the intended witnesses.
Oh, okay.
And to provide them for
Oh, that's a police officer or something?
No, she was an eyewitness at this.
Oh, okay. But she won't be needed until
Right,
tomorrow.
Yeah.
She can be released. The people, now, I don't want dead space though. But, okay, she can be released and told to come back tomorrow. You saying afternoon?
Afternoon, say 2 o'clock, that'd be,
Sure.
okay, I'll let her know, Judge.
Okay.
And also, Your Honor, tomorrow we have an expert coming, and if I would ask the court to allow him to testify out of order, if the prosecutor's not ready, he's available from 9 to 11, or at least in the morning tomorrow, and we're having him come in that I've identified to Ms. Ritter. So if we're not through her case today, whether that would be a problem based on his availability. His name is Kenneth Bora. And also, Your Honor, there is another person in the courtroom. His name is Michael Sherbo, who's P74882.
Oh, he doesn't get an assistant. That's your assistant, right?
I'm trying to keep him off the streets. But here's my son, Michael, and he returned from Charleston, is now working. So
Okay, awesome. And then, do we know who the young lady is in the back of the courtroom?
Yes, ma'am. Support.
that is
And,
a mom.
Okay,
Mom from Mr. Dick.
okay, and she will not be testifying.
No.
Okay, all right. With respect to calling the expert out of order, I guess if we go ahead and get started, Ms. Ritter might be able to get finished. Okay.
I'll let my witness.
Yes, let your witness know, and while you're doing that, the people may, oh, no, it's open statement first. All right, will the people be making an opening statement?
You will, Your Honor.
All right, you're all set, Mr. Farina?
Yes, Your Honor, she'll be back at 2 o'clock tomorrow.
Okay, thank you. All right, I think we've covered all the preliminaries. The people may begin your opening statement.
Thank you, Your Honor. Your Honor, on April 20th of 2018, the complainant witness Christopher Floyd headed downtown to meet up with a couple college friends. The plan was to go out, have a couple of drinks, have a good time with his friends downtown. And eventually, Mr. Floyd and a couple of these friends ended up at the Coliseum bar located on 8 Mile in the city of Detroit. Now, Mr. Floyd and a couple of his friends arrived at this bar about 9 o'clock that night on April 20th of 2018. And you'll hear testimony, Your Honor, from the complainant witness, Mr. Christopher Floyd, as to how he went into the bar, him and his friends were in a booth. He was there for about 40 minutes to an hour, and then he released himself to go to the restroom. Now, Your Honor, there is no testimony from the complainant witness that when he comes out of the restroom, that's when he comes in contact with the 3 defendants that are in court today, Your Honor. Mr. Floyd testified that when he came out of the restroom, he came in contact with Mr. Corey Spencer and another individual who grabbed him by his arms to restrain him. He'll testify that Mr. Ditmore approached him and began punching him continuously in his face. And he'll also testify that Mr. Obransky soon approached and again was punching him continuously in his face. Your Honor, the people have been dealing with this case since 2018, which brings us to about 5.5 years now. I want the court to pay attention to the testimony given by the complainant witness today. And that's important, Your Honor, because like I said, 5.5 years, we're still in court trying to figure out what happened to Mr. Floyd that night at the Coliseum Park. And Your Honor, the people kind of compared this case to a puzzle with one missing piece. And that missing piece, Your Honor, hopefully the people tend to prove to this court that on that day, Mr. Floyd came into contact with 3 defendants and they assaulted Mr. Floyd continuously outside of the restroom at his bar. You'll hear testimony, Your Honor, from Mr. Floyd that he was punched in his face several times by Mr. Bidmore and Mr. Bransky, that it caused his eye to swell and blood running down his face during the time of this assault. Your Honor, the people tend to call Detective Mason as well, who is the officer in charge of this case, and he'll testify to the court as to his role in this case. Like I said, Detective Mason has been on this case since 2018, so he'll explain to the court how we come to this court today with these 3 defendants sitting in the court. Now, Your Honor, the issue that arises from this case comes from identification and intoxication. Now, those 2 issues will be presented by defense counsel, and they'll tell the court that Mr. Floyd was so intoxicated that he couldn't identify any of the parties. That Mr. Floyd mistakenly identified one of the defendants, and therefore he misidentified the other defendants. But I want the court again to pay attention to the testimony that will come through from the complaining witness, who will give a detailed account of what happened on that day in the Coliseum bar, and Detective Mason, who will walk the court through the process and how the lineups were conducted in order to get these defendants identified in court today. Your Honor, the people also tends to bring in a video interview from a statement made by Mr. Didmore. And Mr. Didmore actually comes into the police precinct voluntarily and makes a statement to Detective Mason. So, Your Honor, once the court hears the testimony from the witnesses, once the court sees the photos that people tend to bring through as exhibits to corroborate the events that Mr. Floyd will testify to, and once the court hears the testimony from Detective Mason, the people hope that the court can put that last piece of the puzzle into this picture as to why these 3 defendants are here in court today. And once the court takes all of that evidence into consideration provided by the people wants this court to find Mr. Didmore, Mr. Spencer, Mr. Brent guilty of count 1, aggravated assault, or in the alternative, the lesser included offense, assault or assault battery. Thank you.
Any opening statement at this time on behalf of Mr. Didmore?
Yes.
May we go out of order, Your Honor, and I'll go first?
You may.
Your Honor, again, for the record, Jeffrey Sherbo on behalf of the defendant Corey Spencer. Your Honor, I feel like I just went to a library and went to the fiction column. The facts are so different that will be established before this court that this court could find nothing but reasonable doubt. What's interesting in the testimony will show that Mr. Floyd, the complaining witness in this matter, I don't want to call him the victim, but the complaining witness, blew at 12:36 at night through blood serum of 0.24. Tomorrow, Dr. Kenneth Bora is going to be here and will testify that based on what the real testimony will be from Mr. Floyd, because clearly 5 years later, we can't remember what he said 5 years ago, because 5 years ago, he said he got there at 9 o'clock. That 5 years back, so that 5 hours back from, 3.5 hours back from 12:36 to 9 o'clock, we'll take that 0.24 to a 0.32 to a 0.35 at the time of the alleged incident. What my esteemed colleague fails to tell you that the testimony will not support, other than Mr. Floyd's unsubstantiated testimony, that he walked out of the bathroom and he got jumped for no reason whatsoever. What the testimony will show is that Mr. Floyd was in a drunken, out of his mind condition, takes a young lady into one of those back rooms that I've never seen in my life, Your Honor, and then grabs another lady, Miss Paris Floyd, not related, goes into the back room and the testimony will say, quote unquote, he was just a drunken fool. There's an issue in the back room. Mr. Floyd comes out. He is so intoxicated, he goes after one of the bouncers, ends up being restrained, not by Mr. Spencer, falls to the ground and hits his head on a table and a wall. Then you're going to hear so many inconsistencies in terms of reasonable doubt, but some of those that are really key, there was no identification that night. There was somebody on behalf of Mr. Floyd goes into the bar, takes pictures. There's a ruse performed by the detectives in this case by getting their cabaret licenses and trying to create a photo array. During the photo array, 3 people are picked out of the photo arrays. 2 of them were employees, but not there that night. And the testimony will show Mr. Faison, who's already been dismissed. Mr. Abramsky wasn't even there that night. And then there's some guy whose picture nobody knows, a guy named Michael Sullivan. His picture circled with Floyd. So within a month, there are 3 different photo arrays, 3 wrongly identified people by Mr. Floyd. What's so significant to that is when Mr. Floyd is interviewed by the police, might have been Mr. Detective Mason, he says, I came out of the bathroom, a brother grabbed me who had dreadlocks like the Predator.
No, no, did.
That's what his testimony is going to be. I'm assuming that's what it's going to show. And then he says, so there's a guy with dreadlocks, he says, can't identify. And then somebody else grabbed me from the right, but I don't know who it was. And then some white guys came at me from the front. That's what his testimony is. So for the first 72 hours, he doesn't know who it is until there's these created photo arrays. There's no testimony that the complaining witness can identify anybody. That coincides with the executive functioning deficits that he has when he blows a 0.35 that Dr. Borer will testify to. So during the course of the trial, we're going to, obviously, we have impeachment available testimony for Mr. Floyd because we have sworn statements that he's taken that will be used. There's going to be the evidence of my client. There will be the evidence of the other defendants. We've got 2 guys that weren't even there who are going to testify. So we asked the court, remembering that this is still a reasonable doubt standard, that there is no way that there can be anything but reasonable doubt when you hear the testimony. Thank you.
All right. Any opening statement on behalf of Mr. Bigmore?
Yes, Your Honor. If I may proceed, Judge. Your Honor, my co-counsel's characterization of this as fantasy would be more accurate. It's not an issue of simple identification and intoxication. When Mr. Floyd started drinking at 6 o'clock by himself, before at Flood's bar, then he goes again drinking at Greektown, then he goes to the club. Yes, his alcohol level at 4 hours after the incident is 0.24. Yes, I get that. What happens in this case, though, Judge, is that leads to a fantasy and hope and focusing on reasonable doubt. When you show up and you say that a predator grabs you from behind the neck with dreadlocks, 2 bouncers grab each arm who don't necessarily know much about each other, have formed no mens rea to attack you. You have no argument with them. You come out of the bathroom, one's holding an arm, one's holding another arm, one's holding you in the neck, one stands in front of you, 2 stand in front of you, the white men stand in front of you, the black men hold your arms, and then they start punching. No reason.
It makes no sense. These are people who are employed to keep security, to keep the peace. There's no history of aggression between them and the complaining witness. It makes no sense. It's bizarre. The dancer will testify she was there. She was one or two that he brought to the back, didn't pay, threw the money, but not enough, and caused a disturbance. He then pushes past one of the bouncers and takes a swing at another one. He's then restrained. He is big, and he starts fighting. He created the situation that led to his injuries. He was the aggressor. He put himself in that position by consuming. That's where the intoxication comes into place, and other issues as well, such that he can't even create a plausible version of what happened. That's what we're dealing with, Judge. And if he was injured, and when he was injured, that's his cause, his fault. He's the aggressor. And that's why we're here today. But you know what's interesting also, Judge, I want to finish up by saying this. 5 years of fighting this. My client's gone through hell defending himself and finding the money to try and survive and make this thing work. It's affected all of their lives. All my client and all the people did was to do their job. They don't get paid by fighting people. They don't have protection of the club. There's no motive. There's no mens rea. There's no reason to attack you. But you know what? You keep pushing. You have an assistant as a police officer. You have influence with other ways to push this case and put pressure and not give up and put pressure on everybody and get your way. NFL player, yeah, I get my way. I played for the National Football League. I get my way. That's what this case is about. Bullying and pushing and ignoring. There can be no other reason, no other alternative of what happened that night. Only my way. That's what we're dealing with the Floyd. Thank you.
On behalf of Mr. Brown.
I guess I'm gonna go ahead and take exception to the people's suggestion that what we have to do here is try to figure out what happened. Because I don't think that that's what has to happen. I think that the people do have a burden of proof beyond a reasonable doubt as to what happened. And I believe that the proofs are gonna fail to support the people's verdict. Your Honor, I don't want the court to gloss over the identification and the intoxication issues here, because the fact of the matter is that the people they have to prove all the elements of the crime, but first they have to prove that Derek Abramski was even present. And they have to do that primarily through the identification made by the complaining witness, which they're not going to be able to do. We believe the proofs are going to show, Your Honor, that shortly after this incident occurred, the description that is given by the complaining witness of the person who's supposed to be the white male is vastly different than the physical description of Derek Abramski. We believe that the complaining witness has an absolute motive to fabricate, and that there's pending litigation that's riding on this case, Your Honor. He's intoxicated, he has this lawsuit pending, and the identification that he gives shortly after the incident is wildly different from the way that Derek Abramski looks, Your Honor. We believe that I would agree with Brother Counsel that there's absolute bullying going on here at the part of this complaining witness. That we believe that the evidence is going to show primarily through Detective Mason that Mr. Floyd was absolutely dissatisfied with the progress the Detroit Police Department was making with regard to the investigation. So he goes and takes it upon himself to go do his own investigation, and the result of that investigation, Your Honor, flawed as it was, because he's not a professional, we get this photo array concocted and put together. And the people's case rests upon that kind of activity. That lack of credibility, that level of intoxication. And we believe, Your Honor, as the end of the proofs, that the people will have failed to meet their burdens, not to try to help the court figure out what happened, but they will have failed to meet their burden of proof beyond a reasonable doubt that Mr. Abramski, that's the only one I can talk about right now, committed any assaultive activity. They're not gonna be able to prove that he's guilty even of being there, Your Honor. And we're gonna ask you to find him not guilty.
May call first week. Thank you, Judge. At this time, if people would like to call Christopher Floyd to the stage.
Oh, look like the OIC. Step to the court reporter right now.
Right.
Yeah. All right, step this way. Raise your right hand. Sir, do you swear or affirm that the testimony you're about to give will be the truth, the whole truth, and nothing but the truth, so help you God?
I do.
All right, you may be seated. All right. Okay, Chief, may proceed.
Thank you, Judge. Good morning, Mr. Floyd.
Good morning.
Mr. Floyd, can you state your full name for the record, please?
Christopher Michael Floyd.
And Mr. Floyd, I want to take you back to April 20th of 2018. Do you recall that day?
Yes.
Okay, and on that day, were you in the city of Detroit?
Yes.
Okay, can you start by telling the court, what did you do at the start of that day?
Starting that day, I had plans to meet with a friend later that night. So you want me to start like from the beginning? I just remember being outside and doing my lawn and being sort of in a rush to get downtown to meet up with my friends.
Okay, so who was this friend that you were meeting up with downtown?
Sam Sword.
Okay, and were you meeting up with anyone else downtown?
He was the only one who I knew, just Sam Sword.
And where were you meeting Mr. Sword at downtown?
We had made plans to meet at Floods.
Okay, and around what time did you arrive to Floods downtown?
Approximately 6 o'clock.
And that's at 6 o'clock in the morning, 6 o'clock in the evening?
6 o'clock PM.
Okay, and when you went to Floods, did you travel there alone?
Yes.
Okay, and what happened when you got to Floods?
Well, prior to getting to Floods, I did talk to Sam Sword, and he told me that he was running late. He had friends that came over to his hotel. So I knew he was staying at the casino hotel down the street from Floods. So I drove there and I parked my car and I walked down Floods.
Okay, did you walk alone?
Yes.
Okay, and just to go back just a little bit, Mr. Floyd, Sam Sword, you're referring to him as your friend, correct?
Yes.
Okay, how long have you known Sam Sword?
Since 1994.
Okay, so this is a long time frame. Okay, and you walked to Floods by yourself.
Yes.
When you got to Floods, what did you do?
I sat at the bar.
Okay, and did you order any drinks or food at the bar?
Yes, I did. I ordered drinks.
Okay, do you recall how many drinks you had at Floods?
Maybe 3.
3 drinks? Okay, and how long did you stay at Floods bar?
Approximately an hour.
Okay, and for this whole hour, were you alone or did your friends meet you there?
I was alone.
Okay, so what happens after this hour passes?
I walked down to the casino hotel and went up to visit Sam.
Okay, and how long did you stay at the casino hotel?
We stayed there maybe an hour and a half, 2 hours. It was Sam and he had a group of guys we had grown up with.
Okay, do you recall, the names of these?
I don't know their names.
Okay, do you recall how many other individuals there were?
4.
So in total, how many of you, of individuals were with you?
6.
6 altogether?
6 in the hotel room.
Okay, so 6 plus you, that's 7 individuals.
No, I make 6.
Oh, okay, so altogether, it's 6 people in the hotel room.
Yes.
Okay, and you testified that you guys stayed there for about an hour and a half?
Hour and a half to 2 hours.
Okay, during that hour and a half, 2 hours, did you, do anything in the hotel?
Drink water.
Okay, and did you drink or eat anything else?
No.
Okay, and what happens after, this hour and a half to 2 hours passes?
We hopped in a van and it was their plan to go to the Coliseum.
When you say their plan, who are you talking about?
Sam and his party, people he.
Okay, and, did you decide to go to the Coliseum as well?
Yeah.
Do you recall about what time you guys decided to go to the Coliseum?
That would have to be between 8:30 and 9.
Okay, so you said that, well, let me ask you this. How did you get to the Coliseum?
We all took a van.
Okay, and do you recall what time you arrived at the Coliseum?
It was shortly after 9.
After 9?
Yeah.
Okay, and do you recall where the Coliseum, bar is located?
I know it's on East 8th Mile.
Okay, is that the city of Detroit?
Yes.
County of Wayne?
Yes.
Okay, and what's at the Coliseum, do you know?
Coliseum is a adult gentleman club.
Okay, and have you been to the Coliseum before?
No.
So this is your first time at the Coliseum?
Yes.
Okay, so are you still with these, 5 other individuals?
It wasn't. It was 4 of us now in the car.
Okay, so altogether it's 4 individuals.
Mm-hmm.
You arrived at the Coliseum.
Yes.
What happens when you arrive there?
We valeted the van. We walked in and they checked our IDs and I didn't have cash on me, so they paid my way to get in.
When you say they, who are you?
Sam Sword.
Okay, so when you say they checked your ID, do you recall, who checked your ID?
I don't, it was an attendant at the front, at the door.
Okay, and do you see that person in the courtroom today?
No.
Okay, so this person checks your ID, you go inside of the Coliseum, correct? Can you give a description to the court of the inside of the Coliseum when you first walk in?
So like there, when we walked in and they paid the fee to get in, there's the door, we walked in the door. And what I remember is it's almost like you're on a platform and then straight ahead to the left is the bar area. And it's a seat area, and then to the right is another platform where it's kind of like a private booth you can sit. And that's what we were waiting for the booth to be clean, so we stood there maybe 10 minutes until the booth was clean and they set us down.
Okay, so you go inside and you sit in the booth, correct?
Yes.
Okay, how long do you sit at the booth with these other individuals?
I was probably at the booth 5 minutes.
Okay, and during your time at the booth, did anything happen?
The bar service person came over and took our drink order.
Okay.
And after they left with the drink order, I got up from the booth and walked to the bathroom.
Okay.
To the restroom.
Okay, so you say you were seated for about 5 minutes and then you get up and go to the bathroom?
After I make the order the drink.
Okay, and during this time in the Coliseum, is it, are there lights on or?
It's dimly lit.
Okay.
There's lights on, but it's dimly lit.
Okay, so is it kind of dark in there?
It's not dark. It's not dark. You can see well, it's lights everywhere in the Coliseum. It's like stage lights, and so you can see.
Okay, and you say you go to the bathroom, correct?
Correct.
Do you recall where the bathroom was located from where you were sitting?
Yeah, so I had to walk down like a small flight of steps and straight ahead, walking toward the rear of the Coliseum, and then the bathroom is off to the left.
Okay, do you recall any other rooms being near that bathroom?
No.
Okay, so what happens after you go into the restroom?
Well, on my way to the restroom, I mean, I'm very noticeable of things. But heading to the restroom, when I was walking into the restroom, there was a guy walking out the restroom.
Okay. Do you know who this guy was that was walking out the restroom?
No, I don't.
Okay. Do you remember how this guy looked that was walking out the restroom?
He was taller than me. He wore a baseball cap, a Detroit baseball cap.
Okay. Was he African American or Caucasian?
He was African American.
Okay. And so you go in the restroom. How long were you in the restroom?
Maybe 3 minutes.
Okay. And what happens after you come out of the restroom?
When I walk out of the restroom, as soon as I step out of the restroom, my foot hit the floor and I'm surrounded by the security guards there.
Okay. And do you recall how many of the security guards were surrounded?
At that time, as soon as I walked out, it was 4.
Okay. Can you describe one by one how these security guards look, if you remember?
I remember, but I can't describe the one who was behind me.
Okay. So where are these security guards surrounding you at this point?
When I walked out of the restroom, they were boxed around the door. So as I turned toward where my party was, now my back is to one of the guys. I can't tell you what he looked like.
Okay.
But the other ones, I know what they look like.
Okay. So what happens after you see these security guards?
The one from behind grabs me by the neck in the chokehold.
Okay.
And the other 2 on the side grab my arms.
Okay.
Just for the purpose of the record, is the one that grabs it from the behind the one he can't identify? Well, I'm trying.
No, counsel, is this an objection or?
Well, it's an objection because it's a vague answer. He's
Overruled.
okay.
You made it.
So can you describe the person that was holding your left arm?
Yes.
Describe them to the court.
He was big, he was dark skinned, he's in his room now.
Okay. And can you point them out?
He's the dark skinned black guy, bald head. He hasn't got a left arm.
Can you describe what he's wearing?
I'm
talking about the person you're talking about in the courtroom. Can you point him out and describe what he's wearing?
He has the blue, the red on the collar, like a sports jacket.
Judge, may the record reflect the identification of defendant number 2, Corey Spencer. The record will reflect the identification of Corey Spencer. Thank you. And can you describe the security guard that was holding your right arm?
Yeah, he was taller than Corey Spencer. He was light skinned, bald head. He was a big guy.
Was he African American or Caucasian?
African American.
Okay, can you see that person in the courtroom?
He's not here.
Okay, and then tell the court what happens next.
So I'm being choked from behind. I can't grab. He got my arms, and then one of the white guys, one of the white bouncers, he walked up and he just started punching me in the face.
Okay, can you describe this bouncer, this Caucasian bouncer that you're mentioning?
I actually saw him as we waited for our booth to be clean. At that time, he had long hair. He had a Detroit Lions baseball cap turned to the back. He was wearing gloves. That's what had my attention from when we walked into the Coliseum, was that he had gloves on. So he had gloves on. He had a beard. He had long hair, and his baseball cap was turned to the back.
Okay, and you said this is the person who walks up and starts punching.
Yeah.
So that person, do you see them in the courtroom?
Yeah, he's here.
Okay, can you point that person out and tell me what
He's in the middle.
Can you tell me what he's wearing?
Black jacket, white shirt, tie.
Judge, may the record reflect identification of defendant number 1, Keith Whitmore. Record reflect identification. Thank you. And tell the court what happens after that.
So he was just punching at me, punching at my face.
When you say he, who are you referring to?
Whitmore.
Okay.
I couldn't defend myself, and then at some point, the only thing I could do is try to keep him away from me.
Okay, so let's back up just a little bit, Mr. Floyd. So when you say he was punching you, was it with an open fist or a closed fist?
A closed fist.
Okay, and where was he punching?
In the face, in the eyes. And he also, he was wearing gloves, and he also took his knuckles, and by this time, I can see blood splashing. He took his knuckles and he was digging into my wound.
Okay, and do you recall how many times he punched you in the face?
Maybe 10.
Okay, and what happens after that?
Well, once I tried to keep him off of me, the two guys, the one guy who had me from behind in the chokehold, he released the chokehold. The two guys holding my arms, they kind of threw me down to the floor face first. And at this point, the fifth guy walks up.
Okay, can you describe who this guy who walks up? Hold on. Okay, thank you, Judge. Can you give a description of the fifth guy that walks up?
He was white, he was bald, he was in the courtroom today.
Okay, and can you point that person out and tell me what he's wearing?
He's behind, he's wearing black sweatshirt.
Judge, may the record reflect the identification of Mr. Derek Briggs. The record reflects the identification of Derek Briggs. Thank you. And when Mr. Abramski walks up, you said, what does he do?
So it happened once. When he first walked up, he was standing. So as the one was punching me in the face, Mr. Didmore stood next to him. He did nothing at first.
Who was he?
Mr. Abramski.
Okay.
He did nothing at first. He stood there and watched why this one was punching, the one in the middle was punching me in the face.
Okay, and what happened next?
And once I kicked them away from me and they threw me down, that's when Mr. Abramski joined in.
Okay, so you kicked who away?
Mr. Didmore in the middle,
Okay, and who threw you down on the ground?
the two holding my arms.
Okay, and the two holding your arms, was one of them in the courtroom?
Yes.
And who was that?
The black guy, bald head.
Okay, yeah, Mr. Spencer.
Yes.
Okay, and what does Mr. Abramski do with this?
He started kicking
Okay, where is he kicking?
in the face, upper torso.
Do you recall how many times he kicked you?
I don't.
Okay, do you recall being conscious at this point?
I recall feeling like I was in and out of consciousness.
Okay, describe that to the court, what you mean you were in and out.
Because when they slammed me down to the floor, I went face first.
Okay,
So I kind of feel like for a second, I was out.
okay,
And at that point, I was trying to get back to my knees. They were kicking me in the face, and then they released my arms, and I'm laying face down on the floor. And at that point, I was trying to get up to my knees.
okay. Now, do you recall how long this assault lasted?
I really don't know, but I'll probably say if it was 3 minutes, it felt like it was 10 minutes.
Okay, so where were you at this time when this assault was being taken?
You mean the location?
Yeah, in the hood.
I was right outside the restroom door.
Okay, and from where you are, how far are you from your party, where they're seated at the booth?
My party is probably 15 or 20 yards off, but they couldn't see me in that line. Like where I walked down from the steps to make that left to go into the restroom, that walkway.
Your Honor, I'm gonna object to speculation on the part of the witness, what the party could or could not see. If he's being punched in the face.
Okay, counsel, that's enough.
Thank you.
All right, objection, I'm as to that part of this. Did you understand anything?
Yeah, I understood it, all right. So, Mr. Floyd, let me ask you, from what you could see, not from what anyone else could see, from what you could see, did you see your party at the booth?
No.
Okay, and what happens after you're let go and you're released to the booth?
The defendant in the middle, he grabbed me by by the back of my collar and the back of my belt loop, and he drugged me through a back door and threw me out the back door into the ground.
Pause. Thank you, Judge. So when you say the defendant, you're referring to Mr. Ditmore?
Yes.
Okay, and you said, can you repeat what you said? I'm sorry.
He grabbed me by my belt loop and the back of my collar and drugged me out to the back door and threw me onto the ground.
Okay, was he alone or was he with someone else?
He was by himself when he picked me up and drugged me to the back.
Okay, do you recall where this back door was?
It was right where it was, right behind where the restroom is. So the restroom was on the left and it's directly down that pathway.
Okay, and was this back door you're referring to located near where you were sitting at the booth with your partner?
In that line of view, but further back is next to the restroom.
Okay, so in what direction is this back door? Is it in the direction going towards where your party is sitting or in the opposite?
The opposite direction.
Okay, so what happens after you're outside of the club now?
There was somebody from the Coliseum. I don't know, it wasn't one of the guys who sold to me, but he came out to the back trying to help me get up and get to the back, but I was able to get to my feet myself. I didn't know who he was or what he was going to do to me.
Okay, so at this point, did you call 911?
No.
Who did you call?
I called my partner inside.
Okay, and what happened after you called?
I couldn't get through to him, and I tried to call him a few times, but the call wasn't where I wasn't getting service, so they wouldn't get service.
So what do you do next?
I called a friend of mine.
Who's this friend?
Larry. His name is Larry Massey.
Okay, was he part of the party inside of the Coliseum?
No.
Okay, and after you called this friend, what did you do after that?
Then I called my girlfriend.
Okay, at any point while you're standing outside of the Coliseum, did you call 911?
No.
Why not?
I didn't think to call 911.
Okay, so you called, your friend, you said Mr. Larry Mason?
Massey.
And then you called your girlfriend?
My girlfriend.
And who was your girlfriend at that time?
Erica Augustine.
Okay, and, did you call and tell her what happened?
Yeah, I called and told her that she to come pick me up.
Okay, and what happens after you call and told her to come pick you up?
When she arrived, she looked at me and said, we went straight to the police station.
Do you recall, how long it took for her to get to the Coliseum?
Maybe 45 minutes to an hour.
So 45 minutes to an hour, you're standing or?
I'm standing in the front of the parking lot at the Coliseum close to 8 Mile.
Okay, during this 45 minutes to an hour, did you call anyone else?
I called my sister, and I made a few calls.
Okay, but at no point did you call 911?
No.
Okay, so what happens when your girlfriend comes to the Coliseum?
We immediately drove down to the police station.
Okay, do you recall which precinct you drove to?
No.
Okay, do you recall where the police station was located?
No.
Okay, do you recall how far the police station was from the Coliseum?
I don't.
Okay, so you go to the police station, and what happens when you get to the police station?
The guy, the attendant that was there, he looked at me and said, "You need to go to emergency now."
Okay, when you say the attendant, who are you?
It was a police officer. He
I'm
was sitting in
gonna
the
object
front.
just for hearsay, Judge.
I was at that other thing. So, without telling me what anyone said, Mr. Floyd, when you go to the police station, did you do anything?
I went to the police station twice. The first time we went, we were sent to the emergency.
Okay, so this first visit to the police station was you and your girlfriend?
Yes.
Okay, and then you go to the hospital, And do you recall which hospital you went to?
I don't recall.
Do you recall where this hospital was?
East side, East Road somewhere.
Okay, so were you seen by anyone at the hospital?
Yes.
Okay, how long did you stay at the hospital?
Maybe an hour, hour and a half.
You have one? Right.
I could hear what you said. I'm sorry, Judge, I couldn't hear what you said.
She asked to approach.
Oh.
I saw you put a sticker on it, but can we get the report for the market for us?
Oh, okay, yes, Judge.
I have some exhibits on my desk and I don't know what case they're from, what date, there's no date here.
Okay, Judge. May I approach now, Your Honor?
May.
Mr. Floyd, for the record, I just handed you some documents, and you're done reviewing those documents, put them face down and look up.
Your Honor, just as a point of clarification, I have to testify as to medical records, but there's no foundation.
I'm sorry, I have no idea what it's looking at.
You're done, just put them face down on the ledge of, yeah, thank you. So, Mr. Floyd, I just handed you some documents, do you recognize what those documents are?
Yes.
And what are those documents?
Those documents is my medical report.
Okay, and where did you receive a copy of those documents?
I believe I did.
Okay, where do you recall receiving those documents?
When do I recall receiving them?
Where?
Where is St. John's?
Okay, and what date do you recall receiving those documents?
I don't know the date that I received them, but it wasn't the night that this incident occurred.
Okay, what date is those strike date?
Okay.
Strike date. Where do you recall receiving those documents pertaining to?
I had to drive to St. John's, to pick them up.
Okay, and what do those documents relate to?
Objection, Your Honor, you can't testify as to what those documents are. Maybe it's medical records, but there's no foundation. I'm sorry.
I don't like speaking objections. I like old school objections.
Okay.
Objections.
Object is the foundation.
Objection, foundation. All right, those kind of objections I like. P45706. That's what they talk.
Well, I don't remember the number, but I know the word.
Objection, foundation. Respond.
I'll change the question.
All right.
What do you recognize those documents to be?
Objection, you know, a foundation, but we stipulated to the records already. We've already said on the record, we stipulate to those records.
All right, but then I think Mr. Farina asked for an opportunity to inquire before the court would admit the record.
Just the photographs. We didn't care about those.
Oh,
Right,
not the medical.
right, the
record.
photo.
Oh,
But
right.
he can't testify to what they actually, other than their medical records. from
So the
St.
medical
John's.
records are, well, approaching. Let's go to the back right quick for a minute. Question.
Okay.
Okay.
Excuse me, I'm sorry.
Right. All right. So having had a discussion off the record, Ms. Ritter, I believe these are the stipulated records, and so you don't need to lay the foundation. If the parties have stipulated to these records that you're presenting to the court.
Yes, Your Honor. So at this time, Your Honor, the people need to look at People's Exhibit 1.
And these are the stipulated records, correct?
Yes, Judge, I believe so.
Yes, Your Honor.
Yes,
objection.
and we have
Okay,
Mr.
so then the court will receive People's Exhibit 1, which is the stipulated portion of the records, the witness medical records, but I still want to mark by the court order.
May I approach Judge?
You may.
Does the court like for me to give that support for the non-mark?
Yes.
Before I publish the court?
Yes.
And I'm sure the prosecutor's office has supplied us all with copies of these exhibits.
I'm sure.
Oh.
She gonna try to use my, she gonna say yes and then she gonna try to use
Okay,
my.
I'm good. We got them, but we'll get them. Okay.
So,
Hold on, you gotta wait for the court.
Take a quick 5-minute recess. I just let's use the restroom.
All right, we'll take a 5-minute recess.
Judge, before everybody leaves, is it okay if, my OIC leaves and come back after lunch, or it looks like we probably won't get to it? Oh, yeah, as long as he's here when you need him. Okay, I have a special, let me adjourn the whole trial for him.
We're going on vacation with him, Judge.
Next time we going.
He's gonna blush.
All right, yes. And then we're on a 5-minute recess until 12:05. 12:05 according to that clock back here, because I think it's a little off. So that's off by 1 minute.
Server. I'm sorry. Let's just.
Can you come back up?
No, I just.
Come on, you can have a seat, sir. All right. You can make your seat. You may. Your Honor, at this time, people will publish people that they want. You may. You may. So, Mr. Floyd, where did you go after you left the hospital that night?
Back to the police station.
Okay, and when you went back to the police station, did you make a police report?
Yes.
Okay, and during your report, at that time, did you give the police officer who took the report a description of the defendant in the case?
Yes.
Okay, and what happened after you gave the police report?
After the report, I went home.
Say that again?
I went home.
Okay, and during any time after the day of the incident, did you speak with any detectives regarding this case?
Yeah.
Okay, do you recall who you spoke with?
I believe it was Detective Mason.
Okay, you recall if Detective Mason reached out to you or you reached out to Detective Mason?
He reached out to me first.
Okay, do you recall what date that was?
I don't.
Okay, but it was after the incident.
It was after the incident.
Okay, and did you give a statement to Detective Mason about what happened?
I believe I did.
Okay, and what happened after you gave your statement to Detective Mason?
I remember after I gave my statement to Detective Mason that we scheduled a day to come in and do a photo lineup.
Okay, and did you go in and do a photo lineup?
I did.
You recall what date that was?
I don't.
Okay, do you recall how many photo lineups you conducted with the detective?
3.
3, okay, and what happened after you did those 3 photo lineups, if anything?
Well, the first photo lineup, I was able to pick out 2 of the individuals.
Okay, which 2 individuals you recall picking out in the photo lineup?
One's not here today, and the other one is the African American boy.
Mr. Spencer?
Yes.
Okay, one moment. Calm. There's no way for them to do this for their answer. Yeah. Ask them how I'm supposed to do it. Makes sense. Thank you. And that's with regards to the first photo lineup, is that correct?
That's correct.
Okay, what about the second photo lineup?
The second photo lineup, I wasn't able to pick out anybody from that lineup.
Okay, and what about the third photo lineup?
Somebody clicking their pen and it's really, I can't, it's distracting me from hearing.
Okay.
Okay, continue.
So the second photo lineup, I looked through the photos, I didn't see anybody.
Okay, what about the third photo lineup?
I didn't see anybody.
Okay, so what happens after this photo lineup is complete?
Well, after the second photo lineup, I had 2 of the individuals, and I'm looking for 3 more. I didn't see them, and I remember having a conversation with Detective Mason, and at that time, I pulled out the phone, showing photographs that was taken of the guy that I was looking for that night.
Okay. So let's step back just a little bit. So you have a photo of individuals at the Coliseum?
One individual.
Okay, one individual. When Okay, can you tell the court when that photo was taken?
It was taken the same, the night of the incident.
Okay, who was that photo taken by?
Larry Massey.
Okay, and actually, Judge Mayor Pro. Judge Mayor Pro. You may. So, Mr. Floyd, I just handed you a document. When you're done reviewing the document, just put it back down. Do you recognize the document I just handed you?
Yes.
What is that document?
That's the photo of Mr. Ambrosio sitting that night of Larry Massey.
I'm gonna object as the foundation move to strike. He can't
Okay,
identify.
that's good. Counsel, your response. Judge, the complainant witness is laying a foundation of the photo that he received, which he testified he received in his phone, and he's laying a foundation of identification.
There's no foundation.
Well, he said, he testified that that was a photograph of Mr. Abramski taken the night of the incident. There's no foundation for that. There's not proper foundation for that.
May I ask you what you did?
Yeah.
Did you receive that same photo?
Object is the foundation, because if somebody else took it, we don't, you gotta bring the guy who took the photo to identify.
Overruled, can you continue?
I would join, I would agree, Judge.
But I overruled the counsel, so you all right.
I was gonna ask.
Continue to try to lay your foundation.
Thank you, Judge. Did you receive a copy of that photo that I just handed you?
Yes.
When did you receive a copy of that photo?
I received it that night, the wee hours of the morning of the incident, so that night.
Okay, and has that photo been changed or altered in any way?
No.
At this time, Your Honor, people move to submit people's proposal to the 200 evidence. Any objection?
Yeah, for here, Your Honor.
You may.
Thank you. So, good afternoon, Mr. Floyd. Good afternoon, Mr. Floyd. Pass this picture. How did you come in possession of that photograph, Mr. Floyd?
I had a friend go to the Coliseum tonight. Took the photo.
You had I'm sorry, you had a friend go to the Coliseum. What did you say?
Same night the incident occurred.
Okay. So did the friend go to the Coliseum after you had left the Coliseum?
When I was thrown out to the back, I made a series of phone calls. Larry Massey was one of the guys who I called. And I needed someone to take photos of all the bouncers there that night.
Okay, so the way you came into this, so Larry Massey went to the Coliseum when you were out after you gotten beat up, or when did he do that? Do you know?
It was after I got beat up.
Okay, so after you left the Coliseum, Larry Massey came to the Coliseum and he took this picture.
Yes, he did. I asked him to do that.
Okay, all right. And when did you get the picture?
That same night.
Okay, you got
Could have been after 1 o'clock to the next morning, but I got it that same night.
Okay.
Could have been hours, a matter of hours later.
Okay, you had it after that first lineup though?
Ms. Stevenson,
Yes.
just for the record, and I know this is a bench trial, but you realize you're publishing that picture to me.
Okay, but
You're
not looking at it.
I was for a minute, I looked up and I saw it, and then I said, well, look down, because it's not admitted yet,
Thank you,
but
Judge.
just,
I appreciate that.
No
So
problem.
you have this picture at the time of the first lineup, right?
Yeah.
Okay, but you didn't give this to Detective Mason?
No.
Okay, you had this picture at the time of the second lineup?
Yes,
Did you give it to Detective Mason?
I did.
Okay, so you gave it,
I showed him from my phone who I was actually looking for.
okay, that's the second lineup?
Yes,
The lineup where you still didn't pick anybody out?
I'm looking for two white guys that I want to see in the photo.
Okay, did you show it to him? Did you show it to him then after the third lineup also?
No, after the third line, he saw the photo in the second line, so he knew what he was
Approach,
looking
Your
for.
Honor.
You may. Remember, this is just for dear.
Yeah, I don't have any other questions.
Oh, okay. Oh. And with respect to your claim, are you objecting to the admission of people's proposed exhibit two?
Actually, I don't, Your Honor.
Okay, and on behalf, well, quite frankly, I don't really know how anybody else can have an objection.
Well, it goes to its veracity, Your Honor. I'd like to word here about the photograph, if I may. About how it's taken and when he got it and why we don't have a copy of his phone and why there's no date stamp.
That's outside the scope of what they're for the video, I mean, for the photo.
No, it isn't for the picture.
Hold on now, counsel, it's only gonna be one attorney addressing me at one time, hold
My
on.
assistant's in the back.
Hold on,
Sorry.
hold on,
Sorry.
all right.
May I, Your Honor?
I guess you have to convince me first that you, on behalf of your client, why it's relevant at all about this photograph coming in of Mr. Abramski.
Because it's relevant, Your Honor, because it goes to our entire defense that Mr. Floyd has no recollection of anything that happened. And if he's trying to create this story in front of Your Honor, we need verification as to when that photograph was taken, because we don't have a date stamp, we don't have a phone picture, we got nothing. And it's pretty interesting that.
That's a long objection.
Okay, well, it's not objection,
I
it's
mean, that's a long
explanation.
explanation. Mr. Farina?
You know, I would concur, except I would add, Judge, I would like to ask questions about how or when he contacted Mr. Macy to take these pictures. And if we have any evidence Mr. Macy arrived from that picture, did he give him that printed document? Or was it emailed or sent him by his phone? I don't know, but I want to know.
I know you do, and when you get a chance to cross-examine him, you will be able to maybe know those answers to the questions, so the court is going to.
I'm gonna object to it for the record, Judge, at this point, because he hasn't laid a foundation of how he obtained that picture, hand-printed picture in his, the night that he went to the hospital.
That's a long objection.
Twice to the police station.
I'll concur.
All right, and the objection is overruled, and the court is admitting people's proposed exhibit two, the picture of Mr. Abramski, and believe that all of those issues raised by co-defense counsel can be addressed on cross-examination. This is a bond order. I can't order no fees on the bond. They have to collect money over there.
Yeah.
Or send it to outside agents. There's no provision for us to put these in precinct.
Okay.
All right.
So that this how people, public people, they didn't sue.
You may.
You may. May I continue, Your Honor?
You may.
Thank you. So, Mr. Floyd, you gave that picture, or you showed that picture to the second basic, correct?
Correct.
And you testified, I'm sorry, that was after the second line.
That was after the second line.
Okay, so why did you show this, or Detective Mason, that photo after the second line?
When Detective Mason called me in for the second photo lineup, I was there maybe an hour, and I looked at so many photos. He was going back and forth bringing photos, and he was getting frustrated and questioning whether I knew who I was looking for. And at that moment, I pulled out my phone. I said, "This is one of them."
Okay, so the photo that you showed Detective Mason, You didn't see that person in the lineup that you were showing in the second line, correct?
He wasn't in none of the lineup.
Okay. And then, after you conducted these lineups with the detective, what did you do next?
We were still trying to identify one other person.
Okay.
So I waited, a couple of weeks later, I was calling in for another photo lineup.
Okay, so at this is photo line number 4?
Number 3.
Number 3, okay, so we're on number 3.
Mhm.
And when you went into strike that, where did you go to conduct this photo line?
To the police station.
Okay, and who did you meet with at the police station?
It wasn't Detective Mason, I don't recall who the officer was.
Okay, was it male or female?
It was a male.
It was a male, okay, and at that time, what happened next?
What I remember is that the individual who I was looking for was actually in that photo lineup, but I couldn't pick him up.
Okay,
I failed to pick him up.
okay, and when you say you failed to pick him out, who are you referring to, as we know of now?
The gentleman in the middle,
And that's Mr. Bidwell.
yes.
Okay, so during this third photo lineup, you didn't pick out Mr. Bidwell?
I didn't pick him up.
Okay, and then what happens after you conduct this third photo lineup?
At that point, we just, I waited. I waited for a while to hear back from Officer Mason.
Okay, and after you waited for some time to hear back from Detective Mason, did you hear back from him?
Eventually, I did.
Okay, and without telling me what Detective Mason said, what was the context of what was talked about with Detective Mason?
They were gonna start their investigation. He told me that he had already been to the Coliseum. They were trying to pull video. I mean, this was actually the video part that he was told to me was that they went in there the next week. So if the incident happened on Friday, they went in the next week.
Non-responsive.
I'm sorry.
It's non-responsive. All right.
My question was, what was the context of what the Detective Mason talked about when you went to?
We was talking about pursuing
I'm not
charges.
judging any hearsay. He can talk about what he said.
Hearsay. Response.
Let me rephrase my question.
Rephrase.
What did you do when you met up with Detective Mason? Regarding this investigation?
Just what steps I need to do next to have charges filed.
Okay, no further questions.
All right, it is 12:23. We're gonna go ahead and break for lunch and we will return at 1:30.
Thank you, Your Honor.
You're welcome. Be mindful, Mr. Floyd, you are under oath. Please don't discuss your testimony with anyone.
What time?
1:30.
Yeah, 6 hours.